Direct democracy is a form of democracy in which people decide policy initiatives directly. This differs from the majority of modern Western-style democracies, which are indirect democracies. Related democratic processes. Direct democracy is similar to, but distinct from, representative democracy in which people vote for representatives who then enact policy initiatives. Depending on the particular system in use, direct democracy might entail passing executive decisions, the use of sortition, making laws, directly electing or dismissing officials and conducting trials. Two leading forms of direct democracy are participatory democracy and deliberative democracy. Most countries that are representative democracies allow for three forms of political action that provide limited direct democracy: referendum, initiative, and recall. The first two forms, referendums and initiatives, are examples of direct legislation. Compulsory referendum subjects the legislation drafted by political elites to a binding popular vote. This is the most common form of direct legislation. Popular referendum empowers citizens to make a petition that calls existing legislation to a citizen's vote. Institutions specify the time frame for a valid petition, the number of signatures required, and may require signatures from diverse communities to protect minority interests. This form of direct democracy effectively grants the voting public a veto on laws adopted by the elected legislature. Power of initiative allows members of the general public to propose specific statutory measures or constitutional reforms to the government. And as with referendums, the vote may be binding or simply advisory. Initiatives may be direct or indirect. With the direct initiative, a successful proposition is placed directly on the ballot to be subject to vote. With an indirect initiative, a successful proposition is first presented to the legislature for their consideration. However, if no acceptable action is taken after a designated period of time, the proposition moves to direct popular vote. Such a form of indirect initiative is utilized by Switzerland for constitutional amendments. Power of recall gives the public the power to remove elected officials from office before the end of their term. Although this is very rare in modern democracies, some writers with anarchist sympathies have said direct democracy is opposed to a strong central authority, as decision-making power can reside at only one level, the people themselves or the central authority. Some of the most important modern thinkers who were inspired by the concept of direct democracy are Cornelius Castoriadis, Hannah Arendt, and Pierre Clastres. History. The earliest known direct democracy is said to be the Athenian democracy in the 5th century BC, although it was not an inclusive democracy. Women, foreigners and slaves were excluded from it. The main bodies in the Athenian democracy were the assembly, composed of male citizens, the boule, composed of 500 citizens, and the law courts, composed of a massive number of jurors chosen by lot, with no judges. There were only about 30,000 male citizens, but several thousand of them were politically active in each year, and many of them quite regularly for years on end. The Athenian democracy was direct not only in the sense that decisions were made by the assembled people, but also in the sense that the people through the assembly, boule and law courts controlled the entire political process, and a large proportion of citizens were involved constantly in the public business. Modern democracies, being representative, not direct, do not resemble the Athenian system. Also relevant to the history of direct democracy is the history of ancient Rome, specifically the Roman Republic, beginning around 509 BC. Rome displayed many aspects of democracy, both direct and indirect, from the era of Roman monarchy all the way to the collapse of the Roman Empire. Indeed, the Senate, formed in the first days of the city, lasted through the kingdom, republic, and empire, and even continued after the decline of Western Rome, and its structure and regulations continue to influence legislative bodies worldwide. As to direct democracy, the ancient Roman Republic had a system of citizen lawmaking, or citizen formulation and passage of law, and a citizen veto of legislature-made law. Many historians mark the end of the Republic with the passage of a law named the Lex Tiscia, the 27th of November 43 BC. Modern-era citizen lawmaking began in the towns of Switzerland in the 13th century. In 1847, the Swiss added the Statute referendum to their national constitution. They soon discovered that merely having the power to veto Parliament's laws was not enough. In 1891, they added the Constitutional Amendment Initiative. Swiss politics since 1891 have given the world a valuable experience base with the national-level Constitutional Amendment Initiative. In the past 120 years, more than 240 initiatives have been put to referendums. The populace has been conservative, approving only about 10% of these initiatives. In addition, they have often opted for a version of the initiative rewritten by government. Some of the issues surrounding the related notion of a direct democracy using the Internet and other communications technologies are dealt with in e-democracy and below under the term electronic direct democracy. More concisely, the concept of open-source governance applies principles of the free software movement to the governance of people, allowing the entire populace to participate in government directly, as much or as little as they please. Examples: ancient Athens. Athenian democracy developed in the Greek city-state of Athens, comprising the city of Athens and the surrounding territory of Attica. Around 500 BC, Athens was one of the very first known democracies. Other Greek cities set up democracies, and even though most followed an Athenian model, none were as powerful, stable, or well documented as that of Athens. In the direct democracy of Athens, the citizens did not nominate representatives to vote on legislation and executive bills on their behalf but instead voted as individuals. Participation was by no means open, but the in-group of participants was constituted with no reference to economic class and they participated on a big scale. The public opinion of voters was influenced by the political satire of the comic poets in the theatres. Solon, Cleisthenes, and Ephialtes all contributed to the development of Athenian democracy. Historians differ on which of them was responsible for which institution, and which of them most represented a truly democratic movement. It is most usual to date Athenian democracy from Cleisthenes, since Solon's constitution fell and was replaced by the tyranny of Pisistratus, whereas Ephialtes revised Cleisthenes' constitution relatively peacefully. Hippicus, the brother of the tyrant Hippias, was killed by Harmodius and Aristogeiton, who were subsequently honored by the Athenians for their alleged restoration of Athenian freedom. The greatest and longest-lasting democratic leader was Pericles. After his death, Athenian democracy was twice briefly interrupted by oligarchic revolution towards the end of the Peloponnesian War. It was modified somewhat after it was restored under Euclides. The most detailed accounts are of this 4th century modification rather than of the Periclean system. It was suppressed by the Macedonians in 322 BC. The Athenian institutions were later revived, but the extent to which they were a real democracy is debatable. Switzerland. The pure form of direct democracy only exists in the Swiss cantons of Appenzell Innerrhoden and Glarus. The Swiss Confederation is a semi-direct democracy. The nature of direct democracy in Switzerland is fundamentally complemented by its profound federal governmental structures. Most Western countries have representative systems. Switzerland is a rare example of a country with instruments of direct democracy. Citizens have more power than in a representative democracy. At the federal level, citizens can propose changes to the constitution or ask for a referendum to be held on any law voted by the parliament. Swiss citizens vote regularly on any kind of issue on every political level, such as financial approvals of a schoolhouse or the building of a new street, or the change of the policy regarding sexual work. or on constitutional changes, or on the foreign policy of Switzerland, 4 times a year. Between January 1995 and June 2005, Swiss citizens voted 31 times, on 103 federal questions besides many more cantonal and municipal questions. During the same period, French citizens participated in only 2 referendums. In Switzerland, simple majorities are sufficient at the municipal and canton level, but at the federal level double majorities are required on constitutional issues. A double majority requires approval by a majority of individuals voting, and also by a majority of cantons. Thus in Switzerland a citizen-proposed amendment to the federal constitution cannot be passed at the federal level if a majority of the people approve but a majority of the cantons disapprove. For referendums or propositions in general terms, a majority of those voting is sufficient. In 1890, when the provisions for Swiss national citizen lawmaking were being debated by civil society and government, the Swiss adopted the idea of double majorities from the United States Congress, in which House votes were to represent the people, and Senate votes were to represent the states. According to its supporters, this legitimacy-rich approach to national citizen lawmaking has been very successful. Chris Kobach claims that Switzerland has had tandem successes both socially and economically which are matched by only a few other nations. Kobach states at the end of his book, "Too often, observers deem Switzerland an oddity among political systems. It is more appropriate to regard it as a pioneer." Finally, the Swiss political system, including its direct democratic devices in a multi-level governance context, becomes increasingly interesting for scholars of European Union integration. United States direct democracy was not what the framers of the United States Constitution envisioned for the nation. They saw a danger in tyranny of the majority. As a result, they advocated a representative democracy in the form of a constitutional republic over a direct democracy. For example, James Madison, in Federalist No. 10 advocates a constitutional republic over direct democracy precisely to protect the individual from the will of the majority. He says, "Those who hold and those who are without property have ever formed distinct interests in society. Those who are creditors, and those who are debtors, fall under a like discrimination. A landed interest, a manufacturing interest, a mercantile interest, a moneyed interest, with many lesser interests, grow up of necessity in civilized nations, and divide them into different classes, actuated by different sentiments and views. The regulation of these various and interfering interests forms the principal task of modern legislation, and involves the spirit of party and faction in the necessary and ordinary operations of the government. A pure democracy, by which I mean a society consisting of a small number of citizens, who assemble and administer the government in person, can admit no cure for the mischiefs of faction. A common passion or interest will be felt by a majority, and there is nothing to check the inducements to sacrifice the weaker party. Hence it is that democracies have ever been found incompatible with personal security or the rights of property, and have, in general, been as short in their lives as they have been violent in their deaths." John Witherspoon, one of the signers of the Declaration of Independence, said, "Pure democracy cannot subsist long nor be carried far into the departments of state. It is very subject to caprice and the madness of popular rage." Alexander Hamilton said that a pure democracy, if it were practicable, would be the most perfect government. Experience has proved that no position is more false than this. The ancient democracies in which the people themselves deliberated never possessed one good feature of government. Their very character was tyranny, the figure, deformity, despite the framers' intentions in the beginning of the Republic. Ballot measures and their corresponding referendums have been widely used at the state and sub-state level. There is much state and federal case law, from the early 1900s to the 1990s, that protects the people's right to each of these direct democracy governance components. The first United States Supreme Court ruling in favor of the citizen lawmaking was in Pacific States Telephone and Telegraph Company v. Oregon, 223 U.S. 118 in 1912. President Theodore Roosevelt, in his Charter of Democracy speech to the 1912 Ohio Constitutional Convention, stated, "I believe in the initiative and referendum, which should be used not to destroy representative government, but to correct it whenever it becomes misrepresentative. In various states, referendums through which the people rule include referrals by the legislature to the people of proposed constitutional amendments, referrals by the legislature to the people of proposed statute laws. Constitutional amendment initiative is a constitutionally defined petition process of proposed constitutional law, which, if successful, results in its provisions being written directly into the state's constitution. Since constitutional law cannot be altered by state legislatures, this direct democracy component gives the people an automatic superiority and sovereignty over representative government. It is utilized at the state level in 19 states: Arizona, Arkansas, California, Colorado, Florida, Illinois, Louisiana, Massachusetts, Michigan, Mississippi, Missouri, Montana, Nebraska, Nevada, North Dakota, Ohio, Oklahoma, Oregon, and South Dakota. Among these states, there are three main types of the constitutional amendment initiative, with different degrees of involvement of the state legislature distinguishing between the types. Statute law initiative is a constitutionally defined, citizen-initiated, petition process of proposed statute law, which, if successful, results in law being written directly into the state's statutes. The statute initiative is used at the state level in 21 states: Alaska, Arizona, Arkansas, California, Colorado, Idaho, Maine, Massachusetts, Michigan, Missouri, Montana, Nebraska, Nevada, North Dakota, Ohio, Oklahoma, Oregon, South Dakota, Utah, Washington, and Wyoming. Note that, in Utah, there is no constitutional provision for citizen lawmaking. All of Utah's INR law is in the state statutes. In most states, there is no special protection for citizen-made statutes. The legislature can begin to amend them immediately. Statute law referendum is a constitutionally defined, citizen-initiated, petition process of the proposed veto of all or part of a legislature-made law, which, if successful, repeals the standing law. It is used at the state level in 24 states: Alaska, Arizona, Arkansas, California, Colorado, Idaho, Kentucky, Maine, Maryland, Massachusetts, Michigan, Missouri, Montana, Nebraska, Nevada, New Mexico, North Dakota, Ohio, Oklahoma, Oregon, South Dakota, Utah, Washington, and Wyoming. The recall is a constitutionally defined, citizen-initiated, petition process which, if successful, removes an elected official from office by recalling the official's election. In most state and sub-state jurisdictions having this governance component, voting for the ballot that determines the recall includes voting for one of a slate of candidates to be the next office holder. If the recall is successful, it is utilized at the state level in 19 states: Alaska, Arizona, California, Colorado, Georgia, Idaho, Illinois, Kansas, Louisiana, Michigan, Minnesota, Montana, Nevada, New Jersey, North Dakota, Oregon, Rhode Island, Washington, and Wisconsin. There are now a total of 24 U.S. states with constitutionally defined, citizen-initiated, direct democracy governance components. In the United States, for the most part only one-time majorities are required to approve any of these components. In addition, many localities around the U.S. also provide for some or all of these direct democracy governance components, and in specific classes of initiatives, there is a supermajority voting threshold requirement. Even in states where direct democracy components are scant or non-existent at the state level, there often exists local options for deciding specific issues, such as whether a county should be wet or dry in terms of whether alcohol sales are allowed. In the U.S. region of New England, many municipalities practice a very limited form of home rule, and decide local affairs through the direct democratic process of the town meeting.